Hello, my name is John Smeltz. I will be presenting a Business 501 presentation to you via my PowerPoint and my narration. It will be covering bankruptcy and bankruptcy law. Thank you. All right, my first slide here has discussion topics that I'll be covering. The first is ancient terminology, history behind bankruptcy laws, description of common bankruptcy types, chapters 7, 11, 12, and 13, modern bankruptcy terminology, bankruptcy reform from 1978 to 2005, constitutional issues, ethical dilemmas, and finally a bibliography. My first slide here is titled Origins of the Terms Bankrupt or Bankruptcy. Bankruptcy is tied to the concept of debt forgiveness. It can be traced back to Old Testament times. Moses references a jubilee or holy year which happens every 50 years. This is where all debts were forgiven and the Israelites that had sold themselves into slavery were freed. In ancient Greece, debt forgiveness was unknown. When someone could not pay their debts, the entire family, including servants, became debt slaves. In some areas, they were protected against bodily harm and limited to only 5 years of slavery. The most widely accepted theory behind where the term bankrupt originally came from is the Latin term bancus ruptus, which meant a broken bench or table. For example, when a banker who originally conducted his public marketplace transactions on a bench was unable to continue lending, and meeting his obligations, the bench he worked from was broken in a symbolic show of failure and inability to negotiate. This next slide talks about our origins of next slide covers bankruptcy history, actually. And the first official laws concerning bankruptcy passed in 1542 were titled, An Act Against Such Persons as Do Make Bankrupts. A bankrupt individual is considered a criminal, subject to punishment ranging from incarceration to debtors' prisons to the most extreme penalty, which was death. Between 1557 and 1596, Spain, ruled by King Philip II, declared bankruptcy as a state 4 separate times. Queen Elizabeth I passed a more comprehensive bankruptcy law that laid out basic parameters for the English bankruptcy system. It only lacked the provisions for a bankrupt person to be discharged or finalized in completion of their obligations to their creditors. This law remained in effect until the time of the American Revolution. It was to aid creditors in collecting debts, so only they could file a proceeding. Relief was from debtors, not to debtors. Debtors could be imprisoned. Relief was from debtors, not for debtors. Debtors could be imprisoned for committing fraudulent acts of bankruptcy. An act of bankruptcy was a form of conduct that indicated that the debtor was attempting to prevent creditors from recovering debts justly owed them. One act, as I've listed here, is called keeping house. The debtor would hole up in their home, immune from creditors' reach. By the 17th century, amendments to the law gave the commissioners, what we now know as bankruptcy judges, the power to break into a debtor's house or shop to seize the debtor's property, effectively eliminating the effectiveness of keeping house. Sometimes the debtors were even pilloried and had their ears cut off. Even after a bankruptcy proceeding was complete, the creditors still had the right to pursue collection remedies against the debtor. In a bankruptcy proceeding, all of the assets of the debtor were seized, appraised, then sold. The monies were then distributed to the creditors, and since the discharge concept didn't exist, a debtor could be pursued until death or until the debt was paid in full to all creditors. At this time, the bankruptcy law was limited to traders, known as merchant debtors, and remained that way until the 19th century. Credit was seen as a necessary evil in commerce, and so traders were believed to have peculiar facilities for delaying and defrauding creditors. Non-traders, it was believed, lacked the wherewithal to commit wrongs sufficient to the need of the bankruptcy remedy. During this era, credit was viewed as immoral and almost fraudulent. We continue here with the Statute of Anne. In 1705, the Statute of Anne provided for the discharge of debts for the benefit of the debtor who cooperated in the bankruptcy proceedings with the approval of the commissioner, which was the judge. This was considered to be the root of a more humanitarian legislative treatment of honest but unfortunate debtors. It also provided for the death penalty for fraudulent bankrupts. In 1706, in addition to the commissioner's approval for discharge, creditor consent was added as a prerequisite. Since fraudulent bankruptcy was viewed in the same light as property crimes, both types of crimes permitted the death penalty as a consequence of actions. However, in the 115 years that the bankruptcy law permitted, there were only 5 official executions that were recorded to have ever occurred. 1732, the King George, so we have the 1732 Statute of King George II. It was in effect when the Bankruptcy Act of 1800 was passed in the United States. It used the carrot and stick approach. A discharge and an allowance for the debtor who cooperated, which was the carrot, and death for the fraudulent debtor, the stick. Pretty serious. Many of the colonial states had comprehensive laws governing creditor-to-debtor relationships. Some were bankruptcy laws and some were insolvency laws. It was common for people to be imprisoned due to debt in the colonial era. It wasn't until a constitutional convention in 1787 that federal legislation was discussed, and this was primarily due to discriminatory laws, state laws affecting creditors and commerce from other states. James Madison stated that the power of establishing uniform laws of bankruptcy was intimately connected with the regulation of commerce. Thus, the Constitutional Convention, with very little debate, recognized the interconnection of commerce and economic growth with strength and power of the country, and added the provision for a bankruptcy clause to be included in the United States Constitution. The bankruptcy clause empowered Congress to pass uniform laws on the subject of bankruptcies. Following the ratification of the United States Constitution, the Congress passed several bankruptcy acts for shortened periods of time. In total, the states acted freely in bankruptcy matters for all but 16 years of the first 109 years following the ratification of the United States Constitution. The several acts the Congress passed followed a major financial disaster: Panic of 1797, Bankruptcy Act of 1800, Panic of 1837, Bankruptcy Act of 1841, Panic of 1857, Bankruptcy Act of 1867, and the Civil War, Panic of 1893, Bankruptcy Act of 1898. Each of these acts only lasted an average of 4 years before they were repealed by the Congress. The practice of imprisonment was abolished at the federal level in 1833, and in many states by 1840. England didn't abolish it until 1869. Present-day examples of body execution, as it was called, are usually only seen in cases where the debtor is perceived to be morally culpable, such as when a debt occurs through a fraud or for failure to make child support or alimony payments. The 1841 Bankruptcy Act granted the availability of bankruptcy proceedings to all persons owing debts that wished to file voluntary or involuntary, with the exception of corporations. The 1867 Bankruptcy Act, following the Civil War, required petitioners to take the oath of allegiance to the United States. It was during this time that district courts were given original jurisdiction as courts of bankruptcy, and the judges were appointed registers to assist the judge of the district. These registers later became known as referees, and then, as they are known today, bankruptcy judges. The 1867 bankruptcy law was amended in 1874 to include a provision termed the composition agreement, which allowed the debtor to propose payment of a certain percentage of his debts over time and full discharge of those debts, while keeping his property. This provision was the forerunner of modern reorganization provisions, such as Chapter 13. Following the repeal of the 1867 bankruptcy law in 1878, there were no more federal attempts at bankruptcy law for the next 20 years. All these previously identified bankruptcy acts failed primarily due to criticisms from creditors that included small dividends, high fees and expenses, and lengthy delays. In 1898, the Congress passed a Bankruptcy Act that would last for the next 80 years. Quite an accomplishment based on the history of federal bankruptcy legislation in the United States. By 1894, bankruptcy was being urged only for debtor relief and no longer for creditors. The 1898 Act made it easier for a debtor to get a discharge of bankruptcy and made it such that the discharge was no longer conditioned on the consent of 3/4 of the creditors, effectively making it harder for creditors to get the court to approve of reasons for denial of discharge. Many members of Congress, primarily Southerners, disliked the idea of a permanent bankruptcy law that was used for collection of debts and believed it should only be used for debtor relief. They attempted in 1902, 1903, 1909, and 1910 to repeal the 1898 law, but all efforts failed. In 1910, corporations were made eligible for voluntary bankruptcy. From the 1920s to 30s, the credit industry made strong moves to change the bankruptcy law such that debtors would be required to pay money, if able, as a condition of discharge. Since the Depression was getting worse, the Congress was in no way interested in burdening the people further. Following the low of the Depression in 1929, the Congress made several reforms that were pro-debtor. Over the next 8 years, legislation was passed that created the basis for several more bankruptcy types to support farmers, the railroads, corporations, municipalities in their financial reorganization efforts. The 1938 Chandler Act was enacted, and at its core it revised nearly all the provisions of the 1898 Act, making bankruptcy administration easier, updated substantive law and procedural workings for liquidation cases, and reworked all the recently enacted reorganization provisions previously mentioned. These changes stayed in place for the next 40 years with only minor changes over the years. Next, I kind of want to cover a few of the modern bankruptcy terminologies, so that further on it'll be kind of clear as to what they mean. So some of the terms are creditor. A creditor is a person who the debtor owes money to, or who claims to be owed money by the debtor. A debtor is a person who has filed a petition for relief under the Bankruptcy Code. Discharge is a bankruptcy discharge releases the debtor from personal liability for certain specified types of debts. In other words, the debtor is no longer legally required to pay any debts that are discharged. The discharge is a permanent order prohibiting the creditors of the debtor from taking any form of collection action on discharged debts, including legal action and communications with the debtor, such as telephone calls, letters, and personal contacts. Bankruptcy petition is a document filed by the debtor in a voluntary case or by a creditor in an involuntary case. Confirmation is a bankruptcy judge's approval of a plan of reorganization or liquidation, such as in Chapter 11, or payment plan in Chapters 12 and 13. Let's see, a non-dischargeable debt is a debt that cannot be eliminated in bankruptcy. Examples would include a home mortgage, debts for alimony or child support, some taxes, debts for most government-funded or guaranteed educational loans or benefit overpayments, and other debts that would be arising that maybe arose from death or personal injury caused by driving while intoxicated or under the influence of drugs, and debts for restitution or a criminal fine included in a sentence on the debtor's conviction of a crime. Trustee is a pretty important person. That's the representative of the bankruptcy estate who exercises statutory powers principally for the benefit of the unsecured creditors, under the general supervision of the court and the direct supervision of the U.S. trustee or bankruptcy administrator. The trustee is a private individual or corporation appointed in all Chapter 7s, 12s, 13s, and some Chapter 11 cases. The trustee's responsibility includes reviewing the debtor's petition and schedules and bringing actions against creditors or the debtor to recover property of the bankruptcy estate. In Chapter 7, the trustee liquidates property of the estate and makes distributions to creditors. And trustees in Chapter 12 and 13 have similar duties to a Chapter 7 trustee and the additional responsibilities overseeing the debtor's plan, receiving payments from debtors and dispersing plan payments to creditors. Long definition. The U.S. trustee, finally, is an officer of the Justice Department responsible for supervising the administration of bankruptcy cases. So, this next slide kind of discusses some of the more common cases that are covered in bankruptcy. Chapter 7, the chapter of the Bankruptcy Code that provides for liquidation or the sale of all the debtors' non-exempt property and distribution of the proceeds to the creditors. The bankruptcy trustee gathers and sells the debtors' non-exempt assets and uses the proceeds of such assets to pay the holders of claims, which are the creditors, in accordance with the provisions of the Bankruptcy Code. The code also allows the debtor to keep certain exempt property, but a trustee will liquidate the debtor's remaining assets. In a Chapter 9 bankruptcy, it provides for the reorganization of municipalities, which would include cities and towns, villages, counties, taxing districts, municipal utilities, and school districts. The real purpose behind a Chapter 9 is to provide a financially distressed municipality protection from its creditors while it develops and negotiates a plan for adjusting its debts. In the Chapter 11 bankruptcy, it provides generally for reorganization, usually involving a corporation or partnership. A Chapter 11 debtor usually proposes a plan of reorganization to keep its business alive and pay creditors over time. So people that are in a business or individuals can also seek relief in a Chapter 11, and it's generally referred to as a reorganization bankruptcy. On Chapter 12, bankruptcy, it's for basically provides for adjusting of debts of a family farmer or fisherman, family fisherman, or those are the terms as defined in the Bankruptcy Code. Chapter 12 is designed for family farmers, or as I said, family fishermen with a regular annual income as it identifies in the code. And the reason they say that is it enables, Chapter 12 would enable financially distressed farmers and fishermen to propose and carry out a plan to repay part or all of their debts. And the reason that they want the regular annual income, it's required to file a petition for relief. The purpose is that it's to ensure that the debtor's annual income is sufficiently stable and regular to prevent the debtor to make payments under a Chapter 12 plan. But a Chapter 12 plan does make allowances for situations in which farmers or fishermen have income that's seasonal in nature. Relief under the Chapter 12 is voluntary, so only the debtor may file a petition under that chapter. So none of the creditors can file an involuntary petition against a family farmer or a family fisherman. And finally, in Chapter 13, the chapter of the Bankruptcy Code that provides for adjustments of debts for an individual with a regular income. Chapter 13 bankruptcy is also called a wage earner's plan. It enables individuals with regular income to develop a plan to repay all or part of their debts. Under this chapter, debtors propose a repayment plan to make installments to creditors over 3 to 5 years. During this time, the law forbids creditors from starting or continuing collection efforts. Chapter 13 also offers individuals a number of advantages over a liquidation, which is under Chapter 7. And the most significant probably is that it allows a person the opportunity to save their home from foreclosure. And during this whole period of time, no one can have direct contact. The people, the debtors, cannot have direct contact with creditors while under the Chapter 13 protections. So this next slide, Bankruptcy Reform Act of 1978. So back in 1970, the Congress set up a commission to study and report on the existing law. They filed a report in 1973, and in 1978, the Bankruptcy Reform Act of 1978 was signed into law by President Carter. It replaced the 1898 Act, and it's now known as the Bankruptcy Code. One unique point about the 1978 legislature was that unlike all previous legislative reform acts enacted by Congress, it was not put in place in response to a severe economic depression. Bankruptcy referees were renamed judges in the legislation, and following congressional debates, the bankruptcy judges were allowed jurisdiction, which only included matters arising in or under or related to bankruptcy cases as adjuncts of the district court. The judges were denied Article III status, and basically this meant that they would not be appointed for life, and they were not protected against a change in their salaries. Several issues following this needed to be addressed by Congress following the 1978 Act. And just to point out what they were, the Congress felt that one of the issues was they felt that they needed to respond to court decisions from lower courts and the Supreme Court. Another one was the credit industry was unhappy, again, with the increase in bankruptcies and increase in debt losses, and lobbied Congress to get more strict with the treatment of debtors. Third item was the farming crisis in the early 1980s created a need for a family farmer relief. Another fourth one was the bankruptcy court had unexpectedly become a location where many social issues were being discussed and debated, which was clearly not the right location for it. And special interest groups were trying to get the bankruptcy code changed in their favor. And finally, there was a dramatic increase in caseload following the 1978 Act. And this created an administration nightmare that was clogging the court system and creating a lot of problems for the system. In 1986, legislation was used to create the Chapter 12 bankruptcy, which was specifically designed for family farmers. It allowed farmers to pay creditors over time while keeping their farms. It was supposed to have a sunset provision in it so that it would end in 7 years. However, As with many things in the Congress or in the government, federal-wise, it was initially extended and now is a permanent bankruptcy type. The 1986 bill also made the U.S. trustee system permanent across the country, except for Alabama and North Carolina, where it did not. The trustees perform the administrative and supervisory tasks during the bankruptcy proceedings, as I've alluded to previously, which would allow for the judges to fulfill their judicial role more effectively. In 1993, Congress reaffirmed their support for the program by appropriating $99 million to continue its funding, and that was for the U.S. trustee system program. This next slide talks about the Bankruptcy Reform Act of 1994. This was signed into law by President Clinton. This act was designed to speed up bankruptcy proceedings. It was intended to motivate petitioners to file under Chapter 13 versus Chapter 7, so that creditors might be able to recover more in their claims against bankruptcy estates, and it also created a National Bankruptcy Commission to review, investigate, and suggest changes to existing bankruptcy law. Under this next slide, the Bankruptcy Abuse Prevention and Consumer Protection Act, the BAPCA, it was signed into law by President Bush in 2005. While signing the bill into law, President Bush made the following statement, and I quote, "Under the new law, Americans who have the ability to pay will be required to pay back at least a portion of their debts. Those who fall behind their state's median income will not be required to pay back their debts. The new law will also make it more difficult for serial filers to abuse the most generous bankruptcy protections. Debtors seeking to erase all the debts will now have to wait 8 years from their last bankruptcy before they can file again. The law will also allow us to clamp down on bankruptcy mills that will make their money by advising abusers how to game the system." End quote. This bill requires filers to undergo credit counseling and participate in a personal financial management education program. And U.S. trustees were given an increased authority under this bill and new responsibilities. Some of those included implementing a new means test that would help them to determine a petitioner's eligibility to file a Chapter 7 or a Chapter 13. They were tasked with being the certifying entity for credit counseling services and financial education service providers. So each added responsibility was in an effort to really aid in reducing bankruptcy fraud and abuse. On this next slide, I'm going to talk about a few of the constitutional issues. There are several constitutional issues that exist, some of which have been resolved, but others are addressed on a case-by-case basis. So the first was the question of what comprises the subject of bankruptcies. And what it was determined was virtually any law that readjusts the rights between creditors and a financially distressed debtor falls within the subject of bankruptcies. According to the Supreme Court, the bankruptcy power encompasses the subject of the relations between an insolvent or non-paying or fraudulent debtor and his creditors extended to his and their relief. The next item was to determine whether bankruptcy law is uniform, so uniformity in the code. And the decision was made that a bankruptcy law is considered uniform when first, the substantive law applied in a bankruptcy case conforms to that applied outside of the bankruptcy under state law. Second, the same law is applied to all debtors within a state and to their creditors. And third, Congress uniformly delegates to a state the power to fix those laws. And so even if debtors and creditors in different states receive different treatment, this does not make the law unconstitutional. The courts only look at the laws of the state and how they are applied to creditors and debtors for equality. The third issue is that of state laws that regulated and discussed the relationship of creditors and debtors versus when the preemption of Congress exercising its powers under the bankruptcy clause. And these issues are decided on a case-by-case basis, and the courts is drawing the line between where state laws end, federal laws begin, and can be somewhat cumbersome, and it's clearly not easily defined. The fourth issue, or the courts needed to determine what the relationships were between the bankruptcy clause and other protections or provisions in the constitutional amendments, such as the Fifth Amendment takings clause and the Seventh Amendment that permitted a right to trial by jury. So the Fifth Amendment identifies prohibitions against the taking of private property without just compensation, without due process of law. So this really limits the bankruptcy clause. And the Seventh Amendment preserves the right of trial by jury in suits at common law, as that right existed at the time the Constitution was ratified. And so the Supreme Court has ruled that the bankruptcy clause is limited by other constitutional provisions as well, but primarily by the Fifth and Seventh Amendments. So this brings me to the next slide here on ethical challenges, attorney competency, and then conflicts of interest. So, like I say, one issue of concern deals with whether an attorney is competent to actually represent a client in bankruptcy. Some attorneys would take on a client without proper training in bankruptcy law, basically for the monetary side of things, and they weren't supporting the client, they weren't giving them their undivided ability to actually perform well for them as their representative attorney. Another issue has to deal with the attorney having a conflict of interest when representing a client, such as the attorney may have formally represented a client that's now filing as a creditor in the bankruptcy petition. So since that attorney was a former counsel for a creditor, there's now a potential, or at least for the appearance, of a conflict of interest between, even though the attorney may be former counsel, but is now representing the debtor, and there's concerns there. So the attorneys really have to make sure they don't have a conflict of interest, and not even a perceived conflict of interest. Most states have adopted the model rules of professional conduct, which is used as the standard for attorney conduct. And finally, here's my bibliography. So this concludes my presentation on the concept of bankruptcy, where the laws originated from, the reforms in current constitutional and ethical concerns. Thank you for viewing my presentation, and have a good day. Goodbye.